जय हिंद दोस्तों, वेलकम बैक टू आवर चैनल जहाँ पे हम लोग वाजीराम रवि का प्रीलिम्स क्विक रिवीजन कर रहे हैं जो 2024 का है। यह पार्ट 1 है, मई से लेकर दिसंबर 2023 तक का। और आप लोग को डेट पता ही होगा, 26 मई 2024 को प्रीलिम्स का एग्जाम होने वाला है। तो हम लोगों ने कई सारे टॉपिक्स पीछे कर लिया था और आज हम लोग यहाँ पॉलिटी एंड गवर्नेंस से शुरू करने वाले हैं। तो आपसे बस ये अनुरोध है कि अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ 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 इसे सब्सक्राइब करके हमें सपोर्ट करें और हमारे साथ जुड़े रहें, ताकि हम जब भी डेली करंट अफेयर का वीडियो आप लोग तक पहुँचाएँ तो आप लोग तक इसे आसानी से पहुँचने में मदद हो सके। कमेंट बॉक्स में हमें जरूर बताएंगे आपको हमारी यह पहल कैसी लग रही है और आप इससे कितने लाभान्वित हो रहे हैं। वीडियो को लाइक करें और ज़्यादा से ज़्यादा शेयर करें उन लोगों तक जो इस बार के प्रीलिम्स एग्जाम देने वाले हैं। उन लोगों तक इसे जरूर पहुँचाएं ताकि आप और आपके दोस्त सभी को इसका लाभ मिल सके। तो आइए शुरू करते हैं। आज हमारा टॉपिक यहाँ से शुरू होने वाला है। हियर वी आर, पॉलिटी एंड गवर्नेंस, जिसमें पहला है कॉन्स्टिट्यूशन और इसका पहला टॉपिक होगा आर्टिकल 370। तो आर्टिकल 370 प्रोवाइडेड special status to J&K by permitting it to form its own constitution, flag and administrative autonomy. It restricted parliament's legislative power as the approval of the state government was required before applying law in the state, except the one related to defense, foreign affairs, finance and communication, temporary या permanent. Article 370 listed under the temporary, transitional and special provision in Part 21 of the Constitution could be interpreted as temporary due to Jammu and Kashmir Constituent Assembly's right to modify, delete or retain it. However, the Supreme Court in 2018 ruled that despite the use of term temporary, Article 370 is not temporary. The Supreme Court's decision in Sampath Prakash vs. State of Jammu and Kashmir 1969 affirmed that Article 370 is permanent provision. How is what scrapped? Under the power, using the power under Article 356 Clause 1, Subclause B, the President declared that the power of the legislature of the state shall be exercisable by or under the authority of Parliament. President issued a presidential order under Article 370, Clause 1 of Constitution. The order amended Article 367, which contained guidance on how to read, interpret some provision. The amendmented article declares the expansion Constitutional Assembly of the state in Article 370, Clause 3 shall be read the mean legislative assembly of the state. Article 370, Clause 3 provided that the Article 370 was to be amended by the concurrence of the Constituent Assembly. However, because of the amendment, it can now be done away by a recommendation of the state legislature. In other words, the government used the power Article 370, Clause 1 to amend provision of Article 367, which then amended the Article 370, Clause 3. Changes after abolition of Article 370. Jammu and Kashmir would no longer maintain its distinct constitution, flag or anthem. The resident of Jammu and Kashmir would no longer possess dual citizenship. Since the newly formed Union Territory of Jammu and Kashmir will be governed by the Indian Constitution, its citizens now enjoy the fundamental rights granted by the Indian Constitution. Article 360, which allows for the declaration of the financial emergency, would also be applicable. All laws enacted by Parliament include the Right to Information Act and the Right to Education Act would be enforceable in Jammu and Kashmir. Now, even if a woman of Jammu and Kashmir marries a temporary resident, she would get the right to property. Earlier, women who given property rights on marrying a temporary resident, but in this way, women's children were deprived of property rights. Any citizen of the country outside the state now can get a job in Jammu and Kashmir. With the conduct of election of Panchayati Raj institution, the three-tier system of grassroots level democracy has now been established in Jammu and Kashmir. Organized stone pelting incident have come down from 1767 in 2018 to 0 in 2023. Bans and Hartal have become a distinct memory. Supreme Court upholds abolition of 370. A 5-judge constitution bench led by the Chief Justice of India (CJI) upheld the abolition of Article 370 through a presidential order in 2019 and led to the reorganization of the state of Jammu and Kashmir into two union territories, that is Jammu and Kashmir and Ladakh, and denuded it of its special privileges. Judgment on the key issue, whether Article 370 was temporary or permanent. The court held that Article 370 was always meant to be a temporary feature, as it was intended as an interim arrangement until the Constituent Assembly of the state was formed after the enactment of Jammu and Kashmir Constitution and the state was abolished as a part of India. This agreement was not necessary. It was adopted because of the special circumstances in the state as it was experiencing war condition. Legality or abolition of Article 370. Processes of abolition. Abrogation. It was abrogated through two constitutional order. Constitutional Order 272. It amended Article 367 and added a new meaning. That is, the Constituent Assembly of Jammu and Kashmir now meant Legislative Assembly of Jammu and Kashmir. And Constituent Order 273. It meant at seeking parliamentary consent, which had assumed power of Jammu and Kashmir legislature to recommend that all clauses of Article 370 should cease to be operated. Court's opinion. It held that there was no need to change the meaning of Constituent Assembly of Jammu and Kashmir after the Constituent Assembly of the state was dissolved. Its power to make recommendation also ceased to exist, and the President could have always unilaterally abrogated Article 370. Status of the Constitution of Jammu and Kashmir. The court held that the Constitution of India is a complete code of constitutional governance, and following its application in its entirety of the state of Jammu and Kashmir by Constitutional Order 273. The Constitution of the State of Jammu and Kashmir is inoperative and is declared to have become redundant. Uniform Civil Code. The 22nd Law Commission of India sought the view of religious organization and the public on the issue of Uniform Civil Code UCC. In India, Goa is the only state where all religions have a common law regarding marriage, divorce, and adoption. Article 44 DPSP of the Constitution lay down that the state shall endeavour to secure a UCC for citizens throughout the territory of India. DPSPs are not enforceable by court but are supposed to inform and guide governance. Next topic is process to rename a state. The Constitution of India gave the Parliament power to alter the name of a state under Article 3 of Constitution, which explicitly lay down a procedure to alter the area, boundary, name, or formation of a new state. Proposal to rename a state. It can be initiated either by state government or by Parliament. For initiating the proposal in the Parliament, prior recommendation of President is required. The state legislature sends a proposal in the form of a resolution to the central government. If the state government sends the proposal for changing the name to the center, then the Ministry of Home Affairs (MHA) takes over and gives its consent only after receiving no objection certificate (NOCs) from various departments like Ministry of Railway, Intelligence Bureau, Department of Post, Survey of India, Registrar General of India. Once the state receives a green nod from the MHA, the resolution is then presented to Parliament in the form of a bill. Procedure to rename a state. The bill is referred to the President to the state legislature being affected by the bill for expressing their views on the bill with a specific time. The procedure of sending the bill to the state legislature was not a part of original constitution and was added only through 5th Amendment Act 1955. The view of the state legislature is not enforceable against the President or the Parliament. The Parliament can dismiss the suggestion given by the state legislature if it wished. After receiving the suggestion of the state legislature or at the end of the prescribed time, the bill returned to Parliament when it gets further deliberated upon. Finally, the bill is sent to the President for his assent. Once it receives the President's assent, the bill becomes act and the name of the state is changed thereafter. Next topic is right to silence या right against self incrimination. Context क्या है तो Supreme Court has ruled that all accused have a right to silence and investigators cannot enforce them to speak upon or admit guilty. Article 20 Clause 3 in Part 3 Fundamental Rights of Indian Constitution says no person accused of any offence shall be compelled to be a witness against himself. The right to be presumed innocent until proven guilty, and the right to remain silent is an interrogation essentially follow from this constitutionally granted right against self-incrimination. This right also ensures that police cannot coerce anyone to confess to a crime and obtain a conviction based on that confession. In Nandini Satpathy versus P.L. Dani case, Supreme Court ruled that conquering a person to answer a question within the limits of the police station may result in a violation of Article 20, Clause 3. In the state of Bombay versus Kathi Kallu or Hard case, Supreme Court ruled that obtaining photographs, fingerprints, signature and thumb impression would not violate the right against self-incrimination of an accused. In Ritesh Sinha versus State of Uttar Pradesh, broadened the parameter of handwriting sample to include voice samples. Supreme Court held that would not violate the right against self-incrimination. Right to silence is limited only to criminal cases. It is not available if a person being interrogated under Customs Act 1962 or Foreign Exchange Management Act 1999. Next topic is Women Reservation Act 106th Constitutional Amendment Act. The historic Women Reservation Bill 2023 Nari Shakti Vandan Adhiniyam 2023 was passed by the Parliament in recently concluded special session. Provision: it will allow 33% seat of Lok Sabha and State Legislative Assembly and State Legislative Assembly of National Capital Territory of Delhi to be reserved explicitly for women. For this purpose, the Act introduced the following article in the Constitution. Article 330A for reservation of seats for women in Lok Sabha. Article 332A for reservation of seat for women in State Legislative Assembly. Article 239A Clause BA for reservation of seats for women in Legislative Assembly of Delhi. Article 334A include a sunset provision that would gradually end this affirmative action policy after 15 years. Commencement of reservation. The bill states that its provision will come into effect only after the delimitation exercise has been conducted based on the figure obtained from the consensus completed and published after the commencement of the Act. Seat rotation. Rotation of seats reserved will be done after each delimitation exercise. In 2006, Bihar became the first state to provide 50% reservation of women in panchayat bodies. At present, more than 20 states have 50% reservation for women at the panchayat level. Previous attempts, though through 81st Constitutional Amendment Bill in Lok Sabha in 1996, the bill failed to get the approval of the House and lapsed with the dissolution of Lok Sabha. It was introduced again by the Atal Bihari Vajpayee government in 1998, but it lapsed as the government fell in 1999. It was reintroduced in 1999, 2000, 2002 and 2003, but every time it failed to get passed. The Constitution 108th Amendment Bill 2008 in Rajya Sabha in 2010 was another attempt. The Rajya Sabha passed the bill, but Lok Sabha didn't take it up for voting and ultimately it lapsed with the dissolution of 5th Lok Sabha. Next topic is Haryana's private sector quota struck down by High Court. The Punjab and Haryana High Court quashed the Haryana State Employment of Local Candidates Act 2020 that provided 75% reservation in private job to a state resident. Constitutional articles cited in the judgment. It violated Article 19 Clause 1 Subclause E, which guarantees the right to reside and settle in any part of Indian territory, and Article 19 Clause 1 Subclause G guaranteed the right to practice any profession, business or trade. It infringes Article 40 Equality before the law and Article 15 Prohibition of discrimination on ground of religion, race, caste, sex or place of birth. Next topic, Section 6A of Citizenship Act 1955. Recently, the Supreme Court asked the central government to submit details of the number of immigrants who were conferred into Indian citizenship through Section 6A of Citizenship Act 1955. About Section 6A of the Citizenship Act 1971, introduced to give effect to Assam Accord. It is a special provision for Assam which classified immigrants from Bangladesh or East Pakistan into Assam in 3 categories. Pahla, those who entered before 1st January 1966 were deemed to be citizens of India. Second, those who entered after 1 January 1966 and before 25 March 1971 were categorized as foreigner and were required to register themselves for citizen to be granted after 10 years. Such persons were given the same right and obligation as a citizen, except the right to vote. Third is those who entered after 25th March 1971 were deemed illegal immigrants. The Assam Accord. तो असम अकॉर्ड क्या है देख लेते हैं. तो it was a memorandum of settlement (MOS) signed in 1985 between the Union government under Rajiv Gandhi and leadership of the Assam movement that brought to an end the Assam movement provisions. As per the accord, the Indian government agreed to secure the international border of the country against future infiltration by first erecting physical barrier like walls, barbed wire, fencing, and other obstacle to appropriate places. Deploy a patrol by security forces on land and river route all along the international Bangladesh-India border. तो व्हाट इज फॉरेन ट्रिब्यूनल्स एफटीज क्या है तो उसके बारे में देख लेते हैं. फॉरेन ट्रिब्यूनल्स एफटीज आर क्वासी जुडिशियल बॉडी दैट डिटरमाइन वेदर ए पर्सन इज और इज नॉट अ फॉरेनर अंडर फॉरेनर्स एक्ट 1946. They were first step up in 1964 and are unique to Assam. Under the provision of Foreigner Act 1946 and Foreigner Tribunal Order 1964, only Foreigners Tribunal are empowered to declare a person as a foreigner. Any person not listed in the conclusive National Registrar of Citizenship (NRC) has the opportunity to present their case before the appellate authority, namely the Foreigner Tribunal (FT). In 2019, the MHA amended the Foreigner Tribunal Order 1964 and empowered district magistrates in all states and UTs to set up tribunals. Previously, the center has had sole authority to constitute tribunals. Next topic is the Gyanvapi case. According to popular legend, the Mughal ruler Aurangzeb built the Gyanvapi Mosque in 1669 by demolishing the ancient Vishweshwar temple in Varanasi. It is worth noting that Aurangzeb ordered Governor Abu Hassan to demolish the temple in 1669, according to Saqib's Khan book Yasir Alamgiri. The mosque is not an ASI protected site and the ASI has no role in its maintenance or upkeep. Extra Mile, the place of worship, a special provision Act 1991. The act prohibits conversion of any place of worship and provide for the maintenance of the religion character of any place of worship as it existed on 15 August 1947. की प्रोविजन क्या है तो देख लेते हैं. The act determined place of worship as temple, mosque, gurudwara, church, monastery or any other place of public religious worship. It was judicial review. Prohibition of conversion. The act bars the conversion of a place of worship of any religious denomination into a place of worship of different religious denomination or even a different segment of the same religious denomination. Maintenance of religious character. The religious character of a place of worship shall continue to be the same as it existed on August 15, 1947, and any suit or legal proceeding with respect to the conversion of any place of worship existing on August 15, 1947, pending before any court shall abate, and no fresh suit or legal proceeding shall be instituted. It exempts the Ram Janmabhoomi Babri Masjid case from its ambit and to any suit, appeal, or proceeding relating to it. Section 5 also exempt ancient or historical monuments and archaeological sites and remains that are covered by the Ancient Monument and Archaeological Site and Remain Act 1958. Next topic is permitting puja and ritual at protected monument. A parliamentary committee recommended permitting puja and worship at monuments protected by the Archaeological Survey of India ASI that have religious significance. Background क्या है तो in 2022 prayers were held at the ruin of 8th century Martand Sun Temple in Jammu and Kashmir, Anantnag. When the ASI took over the temple ruin in the 20th century for conservation, no puja or Hindu ritual were being held there. About Martand Sun Temple, it is commissioned by the Karkota dynasty king Lalitaditya Muktapida 1725 AD to 1753 AD in 8th century, and it once used to be a thriving place of worship. It was destroyed by Sikandar Shah Miri in 14th century. the present ASI rule. ASI allows prayer at its protected site only if they were functioning place of worship at the time it took charge on them. No religious ritual are allowed at non-living monuments. The non-living monuments are the ones which where there have been no continuity of worship when it became an ASI protected site. About Archaeological Survey of India, ASI under the Ministry of Culture. ASI is the premier organization for archaeological research and protection of cultural heritage of the nation founded in 1861 by Alexander Cunningham, father of Indian archaeology. It is responsible for maintenance of ancient monuments and archaeological sites and remains of national importance. It regulates all archaeological activities in the country as per the provision of Ancient Monuments and Archaeological Site and Remains Act 1958 and regulates Antiquities and Art Treasure Act 1972. The Ancient Monument and Archaeological Site and Remains Act 1958 provides for the provision of ancient and historical monuments and archaeological sites and remains of national importance. Antiquities Antiquities and Art Treasure Act 1972 was enacted to regulate the internal and external dealing in antiquities in India. नेक्स्ट आवर टॉपिक इज लेजिस्लेटर और उसमें पहला सेक्शन हमारा है न्यू पार्लियामेंट बिल्डिंग. इंडिया सेलिब्रेटेड द इनाग्रेशन ऑफ इट्स न्यू पार्लियामेंट बिल्डिंग इन द 75th ईयर ऑफ इंडिपेंडेंस. ओल्ड पार्लियामेंट बिल्डिंग. द कैपिटल वॉज शिफ्टेड फ्रॉम कलकत्ता टू दिल्ली इन 1911. आर्किटेक्ट एडविन लुटियन एंड हर्बर्ट बेकर. फाउंडेशन बाई H.R.H. प्रिंस ऑथर द ड्यूक ऑफ Connaught on February 12, 1921. Construction कब हुआ तो in 1919 the construction was planned and it took 6 years to complete it. The council house composed A. Legislative Assembly Chamber Lok Sabha, B. Council of State Chamber Raj Sabha and the Chamber of Princes means Library Hall. Architecture कैसा था तो the circular shape of Parliament inspired by the circular shape of 64 Yoni Temple at Madhya Pradesh, Morena. A few Indian elements such as jalis and Chhatris, a dimmed roof atop a pavilion-like structure was added to it. Material used, though it has 144 cream sandstone pillars measuring 27 feet each. Inauguration was inaugurated in 1927 by the Governor General of India, Lord Irwin. New building and its features. So its construction was announced in 2019 and the project was named at Central Vista Redevelopment Project. The plan includes the construction of new parliament residence of Prime Minister and Vice President along with 10 building blocks to accommodate all government ministries and departments. It was piloted by Ministry of Housing and Urban Affairs. Build-up area क्या है तो build alongside the old building and has a build-up area of 65,000 square. It is designed in triangular shape. Seating capacity क्या है तो it has larger Lok Sabha hall based on peacock theme and Raj Sabha hall based on lotus theme with a capacity of up to 888 seats and 384 seats respectively. The Lok Sabha may accommodate up to 1272 seats for joint parliamentary session. Each seat will be equipped with digital system and touch screens. Constitutional halls. It consists of a constitutional hall where the journey of Indian democracy has been documented. Office step क्या तो there will be 92 rooms for the use of Council of Minister as offices. There will be also 6 large committee room and large audio visual equipments. Environment friendly क्या है तो the platinum rated green building embodies India's commitment toward environmental sustainability. It features rainwater harvesting and water cycle system. Divyang friendly. It will be Divyang friendly as people with disabilities will be able to move around freely. Facilities for MPs. A central lounge will be complement the open country yard with a banyan tree will be a place for members to interact with each other. There will be a dining hall and library. Earthquake safe. The building is earthquake safe. Material from across the India. For construction, sandstone were brought from Sarmathura in Dholpur and granite from Lakh village in Jaisalmer, Rajasthan. Similarly, the wood used in the decor is from Nagpur and craftsmen from Mumbai had led to the wooden architectural design. Badholi Beaver from Uttar Pradesh have made the traditional hand-knocked carpet for the building. Gandhi statue, the 12-foot tall bronze statue of Mahatma Gandhi made by Padma Bhushan awardee sculptor Ram V. Sutar, who built a Statue of Unity, will remain on the lawn between old and new building. National symbols. The building is replete with national symbol including the national emblem, the lion capital of Asoka, that weight 9,500 kg and is 6.5 meter in height and is visible from a distance at the entrance. The Ashok Chakra and the word Satyamev Jayate has been carved in stone. Entrance के साथ तो the building has three ceremonial entrance in three side of parliament, the vice president, the Lok Sabha and the prime minister. Singol, a golden sceptre. It was given to Jawaharlal Nehru on the eve of independence to mark the transfer of power from the British. It has been placed near the speaker's podium by the prime minister. Galleries, consisting of a Shilap exhibiting textile installation from across India along with poetry item made from the mitti of all states, and B is Satapatya exhibiting the iconic monuments of India including those from different states, and it is Andyoda Asan Andyoga Asan Foucault podium. Inside the new parliament building there is a Foucault podium that showcases the rotation of Earth, named after renowned French physicist Leon Foucault. This podium takes precisely 94 hours 59 minutes and 18 seconds to complete a full rotation at the latitude of the parliament location. Next topic is Adarman. The Supreme Court recently reviewed the case where the Delhi government challenged the Lieutenant Governor appointment of Adarman. Etymology क्या है तो word Adarman comes from the English word old and man. Initially it refers to elder or a clan or tribute, but later evolved to denote the king's viceroy regardless of age. By the 12th century CE it began to be associated with municipal government and used to describe officers of municipal bodies. This usage continued to the present day. Delhi case. According to Delhi Municipal Corporation Act of 1957, the administrator, the lieutenant governor, has the authority to nominate 10 individuals to serve in the corporation, each aged 25 or above. Power. They do not have any voting rights in mayoral election but play an important role in standing committee election. MCD in House and Ward Committee meeting. They are a part of group which effectively control the MCD's purse string. Next topic is special session of parliament. About parliamentary session, Article 58 of Constitution specifies that President must summon each house of the parliament to meet at least once within 6 months. Borrowed from the Government of India Act 1935. Who planned the session? Cabinet Committee on Parliament Affairs declares the dates and duration of parliamentary session. Once a decision has taken, the committee convey its decision to the President, who then summon the member of parliament to meet for the session. In any timetable, no fixed timetable, but the convention. Each calendar year consists of 3 sessions. Pehla budget session, the longer one. It usually from January end to April end. It includes a recess for parliamentary standing committee to consider the budget. Next is monsoon session. It began in July and concluded in August. Third one is winter session. In the last session of the year, usually held from November to December. A special session of parliament. There is no mention of a special session in constitution or in the rule books of either house of the parliament. Also, there is no specific guidelines on how or when such a session should be convened. However, Article 352, added through the 44th Constitutional Amendment Act 1978, which deal with the proclamation of emergency, refers to a special sitting of the House. A special session is convened by the government for specific occasion like ceremony, parliament, or national milestone. Earlier instance, special sessions have been held in the year 1947, 1962, 1972, 1977, 1991, 1992, 1997, 2008, and 2017 etc. Next, our topic is immunities and privileges to MPs and MLAs. Related constitutional provision. Article 105, Clause 2, it provided immunity to an MP. Article 19, Clause 2 for MLA. From any proceeding in any court, from anything said or any vote given by him in parliament or any committee, or held no person liable for any report, paper, votes, or proceeding in a publication or by or under the authority of either House of Parliament. Article 122 and Article 212. The validity of any proceeding in Parliament. Article 212 for a state legislator cannot be called into question in a court on the ground of any alleged irregularity of procedure. Types of parliamentary privileges. पहला है individual privilege. These are privileges enjoyed by the MP and MLAs. Some of these are: first, no MP can be arrested 40 days before the beginning and 40 days after the end of parliamentary session. MP have freedom of speech in parliament and not liable to any proceeding in any court. They are exempt from jury service during the session of parliament. And second is collective privilege. These are enjoyed by both House of Indian Parliament and a state legislature as a whole, as well as their member and officers. Some of these are: पहला, right to publish its report, debates and proceeding. Second is right to exclude stranger from its proceeding. Third is right to make rules to regulate its own procedure. Fourth is right to punish member as well as outsider for breach of its privileges. Fifth is prohibited court inquiry into the House proceeding. And last is no arrest can be made without the permission of the presiding officer. Next topic is no confidence motion. Article 75 Clause 3 of Constitution specifies that Council of Ministers are collectively responsible to the Lok Sabha. For testing this collective responsibility, the rules of Lok Sabha provide a particular mechanism, a motion of no confidence. The procedure is specified under Rule 198 of the Lok Sabha. The Constitution does not mention either a confidence or a no confidence motion. Who can move it? Any Lok Sabha MP who can garner the support of 50 colleagues can at any point of time introduce a motion of no confidence against the Council of Ministers. A no confidence motion can be moved only in Lok Sabha. It cannot be moved in Rajya Sabha. The motion is moved by the member who submitted it, and the government will then respond to the motion. The opposition party will then have the opportunity to speak on the motion. After the debate, the Lok Sabha will vote on the no confidence motion. The motion will be passed if it is supported by majority of the member of the House. If no confidence motion is passed, the government must resign. Earlier instance क्या तो देख लेते. There has been 27 no confidence motion included in Lok Sabha since independence. The first no confidence motion against the administration of the Prime Minister Jawaharlal Nehru was presented in the Lok Sabha in August 1963. The motion obtained only 62 votes in favor and 347 votes against it. The last no confidence motion was moved in 2018 against the then NDA government. Next heading is disqualification of lawmakers. Article 102 Clause 1 and Article 191 Clause 1 provides for disqualification of a member of parliament and a member of legislative assembly respectively on ground like holding office of profit, being unsound mind, and not being a citizen of India, etc. Section 8 of RPA 1951. This includes a specific offence such as promoting enmity between two groups, barely, etc. Section 8 Clause 2 of RPA 1951 lists offences that deal with holding or profiting or adulteration of food or drugs, and offence under any provision of the Dowry Prohibition Act. Section 8, Clause 4 of RPA 1951. A lawmaker is disqualified from the period of imprisonment and a further 6 years if convicted and sentenced to imprisonment for 2 years or more. 10th Schedule of the Constitution provides for the disqualification of member on ground of defection. Next topic is Ethics Committee in Parliament. The genesis of formation of Ethics Committee in Parliament can be traced to a resolution adopted by the presiding officer conferencing held in New Delhi in October 1996. Each House of Parliament has its own Ethics Committee. Ethics Committee in Lok Sabha. It was first constituted in 2000. Composition no more than 15 members and nominated by the Speaker. Term there they shall hold office for a term not exceeding a year. Ethics Committee in Rajya Sabha. It was constituted in 1997. Composition क्या था? तो it consists 10 members nominated by Chairman of Rajya Sabha. Term क्या है? तो they shall hold office for a term not exceeding 1 year. Function क्या है? To oversee the moral and ethical conduct of the members. To examine the cases referred to it with reference to ethical and other misconduct of the member. Any person or member may make a complaint relating to unethical conduct of a member of the committee. In the case of Ethics Committee, only the MP can be examined for misconduct. Money Bill. Next topic. About. A money bill, as defined in Article 110, is a type of legislation that relate to the appropriation of money for the Consolidated Fund of India, which is the main fund of the government. It typically related to financial matters such as taxation, public expenditure, and public debt. It is the Speaker of Lok Sabha who recognizes bill as a money bill. Criteria क्या है? The imposition, abolition, and remission, alteration or regulation of any tax, the regulation of the borrowing of money or the giving of any guarantee by the Government of India, the custody of the Consolidated Fund of the Contingency Fund of India, the payment of money into the withdrawal of money or the withdrawal of money from any such fund, the appropriation of money out of the Consolidated Fund of India. Next is the declaring of any expenditure to be expenditure charged on the Consolidated Fund of India or the increasing of the amount of any such expenditure. Next, the reception of money on account of the Consolidated Fund of India or the public account of India or the custody or issue of such money. Any matter incidental to any matter specific above. Next is procedure for the passage of money bill. तो इसका प्रोसेस क्या देख लेते हैं. द मनी बिल आर इंट्रोड्यूस्ड इन लोकसभा विद द प्रेसिडेंट रिकमेंडेशन एंड कैन ओनली बी इंट्रोड्यूस्ड बाय अ मिनिस्टर. द बिल इज पास्ड बाय बोथ हाउसेज एंड सेंट टू राज्यसभा फॉर कंसिडरेशन. द राज्यसभा हैज लिमिटेड पावर एंड मस्ट रिटर्न द बिल विद इन 14 days. The Lok Sabha can accept or reject the Rajya Sabha's recommendation, and if accepted, the bill is considered to have passed in the modified form. The Lok Sabha has more power regarding money bills. The President can give or withhold assent to a money bill but cannot return it for reconsideration. Next is question hour and types of question in Parliament. Question hour क्या है? तो generally the first hour of Parliament meeting is for asking question, but in 2014 the Rajya Sabha changed the question hour to start at 12 noon instead of 11 am. In this hour, member of Parliament MPs ask minister question to hold them accountable for their working in the government department. Apart from members, question can be asked to private member as well. The presiding officer of both houses, Rajya Sabha and Lok Sabha, are the final authority to respect to conduct of question hour. There is no question hour on Saturday, even if a sitting is fixed for that day. Types of question. तो क्वेश्चन कितने टाइप के होते हैं देखते हैं. पहला है स्टार्ट, दूसरा अनस्टार्ट, थर्ड इज शॉर्ट नोटिस एंड फोर्थ इज प्राइवेट मेंबर. तो पहला स्टार्ट में देखते हैं. दे आर आंसर्ड ओरली एंड आर डिस्टिंग्विश्ड बाय अ asterisk mark. Supplementary question can follow. They must be submitted at least 15 days in advance. Only 20 questions can be listed in a day. They are printed in green color. Next is unstarred. They require a written answer and are printed in the official report of the sitting of House. No supplementary questions are allowed. They must be submitted at least 15 days in advance. They are printed in white color. Short notice. They relate to a matter of urgent public importance. They can be asked within less than 10 days. Not 10 days notice along with reasons for the short notice. Supplementary question can follow. They are printed in a light pink color and are taken up after a question hour. And next is private member. A question may be addressed to a private member. They are asked when the subject matter pertains to any bill, resolution, or any matter relating to the business of the house for which that MP is responsible. The process followed in the same is the same as in the case of minister. They are printed in yellow color. Our next topic is Government of National Capital Territory of Delhi Amendment Act 2023. Parliament has passed the Government of National Capital Territory of Delhi Amendment Ordinance 2023 and created a new statutory authority, the National Capital Civil Service Authority NSSCSA. About the act क्या था देख लेते हैं. It seeks to amend the Government of National Capital Territory NCT of Delhi Act 1991 and establish National Capital Civil Service Authority NCCSA, which will be headed by Chief Minister of Delhi with the Chief Secretary and Principal Home Secretary of Delhi being the other two members. The NCCA will make recommendation to the Lieutenant Government regarding transfer, posting and vigilance matter of all Group A officer and Dionysus officer post in Delhi. This decision will be based on majority of votes of member present and voting. The final authority to pass order related to this recommendation will lie in the hand of Lieutenant Governor LG. He can also ask for matter relevant to officers before taking a decision. There is no specific provision in the ordinance regarding the transfer, posting, discipline, etc. of Group B and Group C officers, which seems to indicate that the elected government of Delhi would continue to have control over these officers. Article 239 AA Clause 3 Subclause A relates to the specific provision with respect to Delhi. तो ऑर्डिनेंस में क्या क्या देख लेते हैं. तो प्रोक्लेमेशन आर्टिकल 123 of Constitution which deal with the power of President to promulgate ordinance such that if at any time when at least one of the House of Parliament is not in session, the President can promulgate an ordinance due to unavoidable circumstances that require him to take immediate action. Article 213 deals with the power of the governor of the state to promulgate ordinance during recess of a state legislature. Ordinance has the same focus and effort as an act of parliament, but the government is required to bring an ordinance before parliament for ratification. It lapses at the expiration of 6 weeks from the reassembly of parliament if the government fails to introduce it for ratification. If the president withdraw it, if both the houses of parliament passes resolution disapproving the law, rejection of an ordinance implies the government has lost majority. If an ordinance make a law that parliament is not competent to enact under the constitution, it shall be considered void. The decision to bring an ordinance rests with the Council of Ministers as the Parliament act on their aid and advise. The President may return the recommendation to the Cabinet for reconsideration, but if it is sent back with or without reconsideration, the President must promulgate it. Validity क्या है? तो an ordinance is valid for 6 weeks from the date on which the next session start. If the two houses start their sessions on different days, the date of house starting letter is considered. Repromulgation. The government can repromulgate an ordinance if it lapses due to any reason. Next is governor cannot keep bill pending indefinitely, जो कि हम अगले सेशन में करेंगे. इस वीडियो सेशन को यहीं पे समाप्त करते हैं. तो उम्मीद है आप लोग को यह वीडियो अच्छा लगा होगा. तो आप लोग कमेंट में हमें जरूर बताएंगे कि आपको हमारी यह पहल कैसी लगी. और अगर आप लोग हमारे चैनल पर नए हैं और अभी तक हमारे चैनल को सब्सक्राइब नहीं किया तो प्लीज़ इसे सब्सक्राइब करके हमें सपोर्ट करें, क्योंकि इसी से हमें प्रोत्साहन मिलता है और आप इससे भी जब भी कोई नया वीडियो अपलोड होगा तो आपके पास आसानी से नोटिफिकेशन चला जाएगा। तो मिलते हैं आपसे अगले वीडियो लेक्चर में, तब तक के लिए इसे शेयर करें, ज़्यादा से ज़्यादा पढ़ें और जितना ज़्यादा रिवाइज करें उतना अच्छा होगा। तो मिलते हैं आपसे अगले वीडियो लेक्चर में। जय हिंद, जय भारत।